Hello, everyone. I'm Jacqueline Scott, Vice President of the International Association of Lawyers, or UIA, and Director General of the UIA's Institute for the Rule of Law. I am delighted to welcome you today to Lawyers Across the Globe and Around the Clock for the Rule of Law, an unprecedented Rule of Law 24-hour webathon co-organized by some of the leading bar associations and legal organizations in the world: the American Bar Association, the UIA, the International Association of Young Lawyers, the Inter-American Bar Association, and the Law Society of England and Wales. This panel presented by the International Association of Lawyers through the UIA-IROL and the Warsaw Bar Association, who has graciously agreed to host us, will discuss independence of the justice sector, media and civil society, institutional and individual impacts on sustainable development. We are one of 12 different panels being offered for 24 continuous hours by bar associations worldwide to celebrate, address the challenges of, and defend the rule of law, all on this YouTube channel. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense. The rule of law is not merely the stock and trade of lawyers, it is our core value. The universal commitment of the world's lawyers to the rule of law inspired us and many other law societies to join forces and launch this first of its kind webinar. We are proud to be a part of it, and particularly proud to present this panel focused on the importance of independence of judges, lawyers, media, and even civil society for sustainability and economic development. As we know, increasingly, independence is the target of attacks against the rule of law in many countries across the globe. Recognized as one of the main components of the rule of law, independence has become increasingly necessary to ensure the viability of economic and social development. Healthy and sustainable economic and social development requires clearly defined rights and obligations of all stakeholders. Civil society thus relies on a free and independent media to bring awareness to violations of those rights, and on independent lawyers and judges to defend and uphold the rights and obligations in accordance with the rule of law. Our panelists will discuss the importance of independence, its relation to the rule of law, the role of individuals and institutions in protecting independence, and the impact of independence on economic and social development. These next 2 hours promise to be quite interesting, so let me start by introducing our first speaker, the esteemed Dean of the Warsaw Bar, Mikolaj Pietzrak, who has graciously agreed to join us for a short while this morning. Dean Pietzrak, welcome, and the floor is yours.
Thank you so much, Madam President. It's a great honor to be participating in the webathon with such distinguished lawyers who will be appearing before you today in this block, and to be participating in an event that brings together all lawyers from across the world around a very unifying fundamental value that is common to us all, the rule of law. It is regretful that Poland is perhaps an excellent case study of what can go wrong and how the rule of law, or rather violations of the rule of law, can lead to so many misfortunes, so many violations of rights and freedoms. Many of us in countries we like to think of as Western democracies often take for granted that the rule of law, division of powers, independence of the judiciary, these very basic concepts we learn about at the beginning of our legal studies, are something we should pretty much take for granted. They're given, and our job as lawyers is to refine the nuanced parts of the legal system rather than to protect the very core values. Well, we've seen how very easy it is to slip from what we like to think of as a constitutional liberal democracy into a illiberal democracy governed by rule of law rather than being governed by law. I think it is critical to take a look at how this happened in Poland and to be able to recognize these things that take place in different jurisdictions throughout the world. most characteristically, this started with a political seizing or taking control of by the executive of the constitutional review mechanism in Poland, which was the Constitutional Tribunal. The Constitutional Tribunal in 2016 was stacked illegally, unconstitutionally, with 3 judges by a newly elected political formation. And this allowed the politicians to effectively pass any law, regardless of whether it was constitutional or not, because they quite simply had political control over the constitutional review mechanism. At the time, many people participated in protests in the street in defense of the Constitutional Tribunal. This proved insufficient to block its further paralysis or to block further political control over this important constitutional review mechanism, which by definition should be independent of political control. As a result, Parliament was from that point on able to pass any laws, regardless of whether they would have legitimately passed a robust constitutional review test. This include laws subjugating the prosecution, which should be apolitical, to the Minister of Justice. Laws which allowed them to take strict political control over the National Judiciary Council, an important body which was intended to safeguard the independence of courts, judges. The Parliament was able to pass laws effectively giving the Minister of Justice political control over who would be the chair of any given or president of any given court throughout Poland. This control over the constitutional review mechanism allowed the politicians to introduce severe disciplinary measures in order to bring about a chilling effect among judges. And we have seen over time that these mechanisms established in Poland by politicians in order to bring about that chilling effect have been applied with regard to specific judges. Most notably, the Parliament set up a disciplinary chamber, a new chamber of the Supreme Court, and stacked it entirely with political appointees, and gave that Supreme Court chamber, that newly formed chamber, power in all cases regarding disciplinary proceedings against judges. Legal communities, including AIJA, União Internacional d'Avocats, including the ABA, the Law Society of England and Wales, protested on international fora and also intervened in Poland, for which I am very grateful to this day. We all raised concerns together that this kind of subjugation of the judicial sphere to political control would not end well. And we have in fact seen our prophecies, our concerns come to fruition. We have now seen judges who issued judgments which were not to the liking of politicians, of the executive, the legislative powers, face disciplinary measures. We've seen them suspended in the right to adjudicate. We've seen them removed from their office as judges. We've seen their pays cut, and we've seen them forcibly moved to other divisions of courts, all as a means of repression and obstruction. Most notably, we've seen them faced with these obstructions merely for applying Court of Justice of the European Union judgments and for applying European Court of Human Rights judgments. This is all, of course, very detrimental not only to the judges who face these repressions, but ultimately to the people who we as lawyers, judges, prosecutors are to serve. It is their rights that are being dealt with before the courts, and it is above all their right to a fair trial, specifically a fair trial before an independent court, an independent judge, that are being violated. So we have been fighting to get this message across to society, and I think this is perhaps one of the most important lessons to be learned in our Polish case study. The rule of law cannot be defended by lawyers, judges, the legal community alone. The rule of law is at the mercy of the politicians if society does not stand up in defense of the rule of law, and specifically in defense of the judiciary. This is a hard sell. We must educate our children from a very early age that the independent judiciary is a value to be defended, even when we're not happy with a specific case. Many people have gone to court and have not been happy with the outcome. Typically, if there are two parties, one is not going to be happy. But we rely on a mature, democratic civil society to defend the democratic value that is the independence of the judiciary, regardless of whether individuals in that society are happy with the way their cases were specifically dealt with. This is a hard sell, and it requires civic education and vigilance on the part of NGOs, legal communities, the bars, judicial communities, in not only upholding their ideals, including judicial independence, but advocating for that judicial independence vis-a-vis the electorate, vis-a-vis civil society. This is something I think we have learned the hard way in Poland, and it's my hope that the Polish case study will allow others across the world to avoid the same mistakes that we have made. I think it is also worth turning your attention to the fact that while the independence of the judiciary is a recognizable and commonly understood concept in democratic societies, there are other institutions which are intended to be independent from the executive, from the legislative, and there to safeguard rights and freedoms that are equally important as independence of the judiciary, as a free judicial community. Most importantly, next to NGOs, these are bars. There can be no access to an independent court if there is no access to an independent lawyer. Without a lawyer who is independent from the executive and the legislative powers, even the existence of an independent court is insufficient to provide protection of rights and freedoms, these procedural safeguards for rights and freedoms of the people we serve. Behind every independent lawyer, there must be an independent bar to stand behind that lawyer, not only for the sake of the lawyer, but ultimately for the sake of the clients of the lawyer, their rights and freedoms. By safeguarding the independence of the bars, safeguarding client-lawyer privilege, we ultimately serve the same values which are protected by independence of the judiciary. I am sure that these comments ring clearly everywhere across the world in all democratic states. And there's a silver lining to the past 7 years of destruction of rule of law in Poland. That silver lining is we have found a community across the world of people who are like-minded in their struggle to uphold the rule of law, independence of the judiciary, to protect lawyers and judges from repressions and obstructions wherever they may be. We have found friends across the world who have supported us in our struggle and who we strive to support in theirs in protection of our common values. Thank you very much for allowing me to address you at the beginning of this part of the webathon, and I look forward to hearing today's discussion. Madam President, thank you once again.
Thank you, Dean Pietzrak. Very, very insightful comments, and truly a cautionary tale to all of us in democratic countries who think that such things cannot happen in our own countries. It's a very sobering message, but I do believe that with the cooperation and spirit of all of us, we can help defend against such incursions into independence of our professions and the judiciary. So thank you very much for that, sir.
Thank you.
Next, I would like to introduce you to Diego Garcia Sayan, the renowned United Nations Special Rapporteur on the independence of judges and lawyers. Unfortunately, Mr. Sayan could not be with us in person because of his conflicting obligations at the United Nations, but he wanted to be part of our webathon and this topic particularly. And he generously joins us via a video, which we will share with you at this moment.
I am delighted to have been invited to share with you some views today. Unfortunately, overlapping with other activities I had already in my schedule impedes that I can be live with you as it was my desire. Of course, the first and more relevant things that I could say is that for my activity as a special rapporteur, and mainly for the protection of independence of judges and lawyers in the world, the Institute for the Rule of Law of the International Association of Lawyers has been not only a key partner in all this process, but is playing a really relevant role in the world to protect independence of justice and to protect, of course, independence of lawyers. Obviously, the function of lawyers is absolutely crucial for an independent justice, not only for persons directly involved in the cases or for the lawyers, but for the society as a whole. It has to do, in a way, with a key aspect which is access to justice and to due process. As you are perfectly aware, the free exercise of the legal profession and the protection of human rights and independence of justice are closely interconnected. They are related at least in 4 aspects. First, access to a lawyer as an integral part of a due process and a fair trial. Second, to be effective, legal assistance has to be carried out independently, as is established in the UN Basic Principles and in several recommendations in my reports and of my predecessors. Third, the principle of lawyer-client confidentiality that must be respected and which is being threatened in several parts of the world. And fourth, establishment and functioning of independent bar associations. Having said so, you are perfectly aware that we have a problem in several countries by which the authoritarian wave, as we may call it, covering several places of the world, including some countries in the democratic Europe, are attacking, firstly, judges and independent lawyers. Lawyers and independence are today threatened or under attack in several countries in all parts of the world. Many things are being done and many things need to be done, and in that process institutions like yours are really crucial as a persistent following up of what is going on and as a source of very valuable information. Having said so, I must share with you the information that this year, the ongoing year, is my last year as a special rapporteur. My second term finishes at the end of the year. And my last report to the UN Council of Human Rights, to be presented in June this year, deals precisely with the rights of lawyers and the abuses being committed against lawyers all around the world. So that's a very important thing that in which I have received support and information from many organizations, including yours. So the report is ready, being translated and being presented in the second week of June, whose purpose is to provide an international account of the significant attacks taking place against lawyers in different parts of the world, and different mechanisms used to undermine the work of independent lawyers, and of course some recommendations that have been built together with different organizations of lawyers in the world. My congratulations for this meeting, and of course, again, my excuses for not being able to be live with you today, and my deep appreciation for all the support that I have received in these years, and to Jacqueline Scott, especially my very good friend. I hope that we will have other opportunity this year on them, and then after I finish my mandate, to maintain our contacts for the protection of the rights of lawyers and to the strengthening of the rule of law. Thank you very much.
Our thanks to Mr. Garcia Sion. We are very grateful to him for his exceptional work at the United Nations, and especially for taking time out today to share his knowledge and expertise with us. I look forward, as I'm sure you all do, to reading his report that he'll submit in June to the Human Rights Council, which details the threats against the independence of lawyers and his recommendations to address what is increasingly a dire situation. So now I know that you all are probably as anxious as I am to hear the panelists that we have today. So without further ado, may I introduce our distinguished moderator, Wojciech Bagiński, who is chair of the International Relations Committee of the Warsaw Bar and the National Bar Association of Poland. Licensed to practice law in the US, Poland, England, and Wales. It's quite impressive. Mr. Bagiński is co-founder of Impactive Law, a boutique international law firm focused on B Corps and sustainability. And he's also the co-founder of the Interdependence Coalition, supporting the EU in introducing a directive on stakeholder corporate governance in Europe that will mandate more social responsibility of corporations. We are honored to have Mr. Bagiński lead this panel. And Wojciech, the floor is yours.
Thank you, Madam President. Jacqueline, thank you very much for introducing me, for your kind words. I will have a pleasure to moderate our discussion today, and we'll focus around the rule of law in Europe, Tanzania, and the Middle East North African region. We have great distinguished speakers with us today, who I will first shortly introduce. First, we have Pauline Adès-Mével. She's an editor-in-chief and spokesperson for Reporters Without Borders, which she joined in 2016, where she started as head of the EU Balkan desk, and has monitored the freedom of information in the European Union's 28 member states and the 6 Balkan countries, and also candidates for admission to the EU. Beside the Reporters Without Borders, she is the president of, sorry if I get this wrong, Trade the Union, an association that aims to raise awareness and train journalists and future journalists on European issues. She also teaches journalism at Sciences Po Journalist School in Paris. Prior to doing this work, she worked as a reporter for the television division of Thomson Reuters in Paris, and for the Associated Press, and also for Canal Plus. So, hello, Pauline.
Thank you very much for welcoming me. Thank you very much and I'm very pleased to join this panel tonight to discuss the rule of law and the role of journalists. Thank you.
Thank you. We have also with us Mr. Saïd Benarbia. He's a director of Middle East and North African program of the International Commission of Jurists. Saïd leads the ICJ research, advocacy, and litigation work in the MENA region. For the past 18 years, He has designed and implemented strategic initiatives on the applicability of international humanitarian and human rights laws during armed conflicts, justice and rule of law reform, women's access to justice, combating impunity for sexual and gender-based violence, and human rights and counter-terrorism measures. Saïd has investigated, researched, and authored numerous reports and articles on the above-mentioned topics, and is an expert in the areas of criminal justice reform, transitional justice, constitutional reform, detention and fair trial rights, and counterterrorism, and the rule of law. Hi, Saïd.
Thanks so much for the introduction.
We have Mr. François Godbout, Program Officer, International Relations at the Pan-African Lawyers Union. François is a practicing lawyer admitted to the Quebec Bar Association. He is the Director of Programs at PALU. He works with high-level officers of African intergovernmental organizations, with the leadership and membership of the bar associations and law societies throughout the continent, and with a wide range of civil society organizations internationally. François was a legal assistant, the defense team, in 2011 and 2012 at the International Criminal Tribunal for Rwanda, and contributed to dozens of successful human rights cases before the East African Court of Justice and the African Court of Human and People's Rights. Hi, François. Good to have you with us.
Thank you very much for having me. It's my utmost pleasure to be with you all today and to share our points of view for fruitful discussions here. Thank you.
Thank you. And last but not least, my good colleague from the Warsaw Bar Association, Mr. Michał chodorek. Michał is a partner in the life sciences team at KRK, Kierzkowska-Rutkowska-Kolasiński. He's a specialist in the field of life sciences laws, including pharmaceutical law and medical devices law, as well as personal data protection and IP new technologies in the healthcare and life sciences industries. In parallel to his professional work, Michał has been recognized and engaged in the fight for the protection of the rule of law in Poland since 2015, when the current Polish government came to power. He has been cooperating with the Warsaw Bar Association as well as the American Bar Association and different NGOs such as Lawyers for Lawyers on projects concerning the rule of law and the protection of judges and lawyers defending the rule of law from persecution. Michał, as always, good to have you with us.
Thank you, Wojciech, and it's my pleasure to be here.
Great. I am looking forward to a great discussion today. We have really good speakers, distinguished speakers, and I'm looking to gain lots of new insights and new learnings. Let me kick off with starting a question, posing a question to Michał. Since our dean started the discussion a bit and made an introduction on Poland, a lot of things are going on in my and Michał's country in relation to the rule of law. The situation is dynamic, and there seems to be a dispute or a series of disputes regarding the fundamentals of the rule of law in Poland with the EU Commission and other EU institutions. Can you, Michał, tell us a bit more about the situation on ground? What are the main issues? How do you see that?
Yes, of course. And like you said, Mikolaj already gave an excellent summary of the broad topics which are at stake. So if I wanted to be ironic, I would say that the current Polish government is responsible for the tremendous development of CGEU and ECHR jurisprudence on the rule of law and independence of the judiciary and independence of the legal profession, because as of today, I think at least the last time I checked, we have over 24 cases concerning Poland, which either have already been heard or are pending before the CGEU. We have, I think, 27 cases either pending or already decided before the ECHR. So that's a tremendous amount of cases. And speaking only, of course, about European courts, I'm not even starting to talk about all the jurisprudence and legal rulings issued in Poland concerning those issues. So what's actually at stake is, if I wanted to say it in one sentence, is the basic principle: can the executive, can the government do whatever it wants to judges and in all issues concerning judges and the legal profession in general, or are there any stops on their powers? Because this is was actually at stake in Poland, and this is the battlefield we've been seeing and working on since 2015. To give you just a short summary of everything that's happened, from the moment the current government came into power, which happened way back in 2015, we've seen a concerted and, I would say, really thought through attack on the basic principles on the rule of law. It started with attacks on the Polish Constitutional Tribunal, which rules on all kinds of laws, whether they're compliant with the Polish Constitution. And it basically snowballed from that, because once the Constitutional Tribunal was attacked and the government was able to pass any kind of law without any type of impediment from the Constitutional Tribunal, it then attacked the Polish Supreme Court. It attacked the Polish National Judiciary Council, which is basically a watchdog, theoretically responsible for defending the judiciary and defending the independence of the judiciary. Of course, this basic function has been completely subverted after it's been taken over by representatives of the current government. Then another step in those attacks has been a new kind of law, which basically stated that implementing judgments issued by the ECHR or issued by the CJEU is a disciplinary infraction on the part of a judge. And we've been calling it the muzzle law. So this was the next logical step from the perspective of our government in limiting and destroying the independence of the judiciary. Another step taken by the current government was the reform of disciplinary proceedings concerning judges. And all disciplinary proceedings against judges in those cases have been put under the purview of the newly created disciplinary chamber of the Supreme Court. And of course, needless to say, the disciplinary chamber has been packed by people elected by the subverted National Judiciary Council. So the disciplinary chamber actually is the strong arm implementing the policies of the current government. And just to round things off, you don't have to take my word for it. I mean, we can dispute this, to the end of time if you just see it as my opinion. The important point here is this is not just my opinion. Like I've said, there's been a great big number of rulings from the CJEU and from the ECHR and from the Polish Supreme Court before it also was taken over by the current government, saying exactly this, saying that all those reforms are unconstitutional, they are in breach of EU law, they are in breach of the European Convention of Human Rights, that the disciplinary proceedings against judges are in breach of all of those acts, that starting disciplinary cases against judges for the very fact of implementing CJEU judgments is in direct and obvious breach of EU law and the European Convention of Human Rights. That suspending judges for those kinds of action, for implementing and respecting judgments of the CJEU, is in direct breach of EU law and the European Convention of Human Rights. So all of those issues have been decided by the courts of the land, by the courts that Poland is obligated to respect and implement their judgments. And this has been happening since 2015, like I've mentioned. So we have a huge amount of time and issues and court cases behind us. It's already 2022, and all of those attacks on the Polish judiciary and on the independence of the Polish judiciary are still ongoing. On a bright note, we've seen tremendous activity and tremendous solidarity and readiness to take action and expose oneself to danger of disciplinary proceedings and even criminal proceedings on the part of judges, on the part of advocates, on the part of the legal profession as a whole. So all of those cases before the CJEU, all of those cases before the ECHR, that would not have been possible if Polish judges did not say, okay, I'm ready to take that risk. I'm ready to be subject to criminal proceedings, to disciplinary proceedings, but I'm gonna raise that issue with the European courts. I'm gonna try to fight all of this. And that it would not have been possible without Polish advocates, the Polish legal profession, supporting Polish judges and then fighting against all of this. So that's the bright light in the tunnel. And stepping back, what I take from all of this is, well, maybe again, building upon what Mikolaj said, that you have to have broad political support in the society as a whole to defend the rule of law. So building on that, the joint action of the legal profession in Poland is what gives time to the civil society to act, to organize itself. Because without those organized acts on behalf of the legal profession, my opinion is that the current government would have already subjugated the judiciary as a whole to its political power. And what we're seeing, the highest echelons of the judiciary have been taken over: the Supreme Court, the Constitutional Court, the National Judiciary Council. But the common courts and all of those judges working in the common courts and adjudicating in the common courts, those are the people who are defending the rule of law, 7 years on after 2015. It's 2022, and those judges are still working, still defending the rule of law. So those are the people whose concerted actions make it possible to still defend the rule of law in Poland and still meet with everyone and tell everyone that there is a real possibility of overturning all the evil that's been done and returning the rule of law to its rightful place.
Yes, thank you very much, Michał, for this intervention. Lots of interesting points. One that I would like to make is that the light in the tunnel, or maybe the good thing regarding this whole situation in Poland, is that actually Polish judges, advocates, and the society, we started asking the European Court for clarifications on the rule of law topic. So we have basically this situation in Poland. It moved a bit the jurisprudence of the European court system, of the rule of law system in Europe. If you look, for instance, at the case of Hungary, the judges from the European Court of Justice, they're asking why there are no motions coming from Hungary. I guess they were a bit too late in their resistance towards the changes that the Hungarian government started introducing. But I would like to move and pass the microphone to François. When preparing for the webinar, we discussed the situation in North Africa, but you mentioned especially the situation in Tanzania. Could you describe the current situation regarding the rule of law there? What are the main issues? What are your thoughts on the situation? The microphone is yours.
Thank you very much for giving me this opportunity. It is indeed a pleasure for me to be discussing the situation in Tanzania, a country where I've been living and calling home for 15 years. During that time, the country enjoyed extraordinary stability, boasting a relatively high level of independence and freedom for civil society actors. But changes did happen in the legal landscape that have been implemented that we could qualify as troubling. It is important, of course, although it goes without saying that lawyers should be protected in the exercise of their profession. But these protections ought to be extended also to other civil society actors whose work involves pursuing interests beyond their own personal gain. For example, and especially journalists. I will concentrate to these two categories of stakeholders from the polity, especially considering the extraordinary representation we had as an introduction on the judiciary. Unfortunately, and this is too often not the reality, and I could obviously give numerous examples to underscore that point, independence is not real. I will not, however, provide such examples because they are well known and well documented. What I will, however, concentrate on is the legislative arrangements which limit these protections, weaken institutions, and threaten the independence and capabilities of these important actors. When we are discussing rule of law, legislative arrangements are central to the protections of the rule of law. But what happens when parliaments are actually adopting arrangements that go against the constitutions and protected human rights? It is important to note that these legislative amendments have the effect of targeting all dissent and independent voices, not just lawyers, but also civil society, the media, and social media spaces. For instance, in Tanzania, what has become a rule is charging the opposition figures with money laundering, which is a non-bailable offense in Tanzania, and therefore ensuring a weakening of their positions by putting them away without opportunities to be let free while the case is being conducted. So this is a big popular means of attacking the opposition, journalists and lawyers that are representing them. If we're looking at the legislative arrangements, we can start with lawyers, which is our main constituency here today. The Act of Parliament that is governing the Tanganyika Law Society, which is the body representing the interest of lawyers on Tanzania mainland, was twice amended in 2018 and 2020 to protect to weaken the protections afforded to the profession. This came very quick on the heels of vocal voices opposing the government policies that they believed offended the public good. These very vocal human rights defenders and what we can consider as foremost government critics had to be silenced. These amendments aimed at weakening the internal self-governance structures of the bar by formalizing clear interference mechanism from the executive. Many other attempts at restricting rights in Tanzania through legislative outreach can also be identified with broader consequences to other stakeholders within the polity. There's an amazing report that has been produced and published yesterday, actually, from a leading civil society organization in Tanzania called the Center for Strategic Litigation, based in Zanzibar, that has developed an extensive list of all of the amendments, and they have mentioned what they raise as concerns. And it goes mostly to freedom of expression, press freedom, freedom of association, and access to the information. There are a few, and they have multiple dynamics in place, such as the Cyber Crimes Act, the Electronic and Postal Communications Act, the Access to Information Act, Statistics Act even, and the Media Services Act. One example, though, that I want to highlight is the one from June 2020, when they passed written laws that is considered miscellaneous amendments that actually abolished public interest litigation in the country. Obviously, this restriction is being challenged in court as we speak, and we have good hope of winning and removing that amendment from the law, but it shows the extent to which the government was ready to go to reduce rule of law in the country. All of these legislative changes obviously contribute to the shrinking of the civil space and limit freedoms of association expression in the country. As such, the question remains, what happens to that space? Or where is that space left? The struggle continues, of course, and we, as the Pan-African Lawyers Union, the organization that I'm representing today, we have been litigating and advocating broadly in conjunction with other members of the civil society and of the bar association in the country. But we can ask ourselves, are courts really independent? And will decisions, especially from regional courts and continental courts, be fully and effectively implemented? Doubts can be cast on both fronts, unfortunately. And that's the situation I wanted to highlight to start the discussion today on the situation in Tanzania. Thank you very much.
Thank you a lot, François, for this intervention. Very interesting topic. Since we are on the African continent, I would like to turn to Saïd, who is working in the Middle East and North African region. Can you describe the current situation in the region regarding the rule of law? What are the main issues? What are your thoughts? Could you bring us closer to the topics there?
Sure. It would be difficult, I think, to cover the whole MENA region, so I would focus basically on the situation in Tunisia and in Egypt and try to be brief. In Tunisia, since the 25th of July 2021, democratic institutions, the rule of law, the separation of power, judicial independence are under assault. Invoking Article 80 of the Constitution on state of exception, the President Saïd, declared himself the head of the executive branch, the head of the office of the public prosecutor. He suspended the parliament. He suspended most of the constitution. He dissolved the parliament afterward. And he initiated a comprehensive assault on judicial independence and on judicial institutions. Not only that, I think through decrees and through unilateral decisions, he also entrusted himself with the power of legislating, of also intervening in judicial matters. On the judiciary in particular, there has been several attacks that try to limit that targeted the members of the Higher Judicial Council, the constitutional body in charge of ensuring judicial independence. There was a decree that ended the financial allowances and other privileges provided by the law to the members of the Higher Judicial Council. And then there was Decree 11, 2022 on the Higher Judicial Council, on temporary Higher Judicial Council. So basically the presence dissolved the legitimate, the constitutionally and lawfully established Higher Judicial Council and replaced it with another council that is subordinated to it. So in terms of background, the Constitution provides for the Higher Judicial Council to be composed of a majority of judges who are elected by their peers, for the Higher Judicial Council to be independent of the executive branch and other branches of government and other stakeholders, and provide also for the Higher Judicial Council to be the sole body or the sole legitimate authority in charge of managing the career of judges and dealing with issues related to appointments, promotion, transfer, and disciplinary issues related to the judiciary. Without any constitutional basis, without any legal basis, the president decided to change, to abolish the law on the Higher Judicial Council, to establish a new body that is composed basically of all members who are appointed by the president, either directly or indirectly. In terms of the management of the career of judges, it's not only the responsibility of the temporary Judicial Council established by the president, it is also the responsibility of the executive branch right now. And the president, under the decree, has the power to object to any decision related to the management of the career of judges, any decision related to the appointment, transfer, promotion of judges. Not only that, the decree gives the president the power to initiate disciplinary proceedings against judges in cases of judicial misconduct, knowing that there is no code of judicial conduct or ethics in in Tunisia that would define in clear, detailed way what are the acts or omissions that might amount to judicial misconduct. And the president has the power under decree to request the immediate suspension of a judge, and that request is complied with by the temporary judicial council. And I think in quite significant, I'm not sure if it's and the ICJ has been working, my organization has been working on issues related to judicial independence for the past 70 years. Not sure we have documented an instance in which the president is acting as a disciplinary body and the president has the power to remove judges directly in case the High Judicial Council is not dealing with or not dealing with the investigations or the cases referred to it by the Ministry of Justice. So through this decree, through the actions of the president, we are moving from a situation in which the judiciary has the institutional independence and the framework governing the work of the judiciary allowed for the individual independence of judges to a system in which judges are subordinated to the president and the president has the power to dismiss them at his will and have discretionary power to determine what kind of acts or omissions might amount to judicial misconduct. And through the subordination of the judiciary, I think the president is cementing his power grab, is dismantling all the instances and institutions that can act as a check on the arbitrary use of power and on his power grab that he initiated 9 months ago. And amongst those institutions as well, there was the instance in charge of the elections, the body that monitors, that organized the elections and referenda in Tunisia. The members of such instance were elected by the parliaments. The president, again, without any constitutional basis or legal basis, changed or introduced a decree amending the law on the instance on the elections and made sure that all the members are again appointed directly by the president without any involvement of the parliament or other stakeholders. As I mentioned also in relation to the attacks on the rule of law, the president suspended most of the constitution to highlight that the Tunisia constitution is the product of, and I think it's maybe the only product in the MENA region that came throughout a process that was inclusive, transparent, drafted by a legitimate constituent assembly that was elected by the Tunisian people, and that's reflected or complied in most of it with international standards on rule of law and separation of power and judicial independence, but also on human rights obligation of Tunisia. And that constitution is now being suspended, and the president is initiating a new process to replace it by a new constitution or constitutional amendments. We don't know yet. There is a referendum that is to be organized on 25th of July, and that referendum is to be conducted on the basis of draft constitution or draft amendments to the constitution that would be developed by a committee that's not been appointed yet, 2 months before the referendum, in a process that is opaque, that is not inclusive, and without any guarantees that it would reflect the views of the various stakeholders. So that's the situation in Tunisia, and I think in terms of some element of it echo what's happened in other countries in the region, in particular Egypt. And I would be brief here, just 2 or 3 minutes, just to highlight some elements since 2013 and the military coup that took place in Egypt. We are witnessing a total breakdown of the rule of law. 2 major elements when we're discussing what the rule of law means in practical terms, and one of the core elements of rule of law is the subordination of the military to civilian authorities and to legally constituted civilian authorities. In specific case of Egypt, we are witnessing a subordination of civilian authorities to the military, and the military, including through the constitutional amendment of 2019, is placing itself above the constitution. It's intervening in political affairs, intervening in economic affairs, and the military is granting itself through the constitution the power through the amendment of 2019 to be, just as paraphrasing exactly the keywords that expand the authority of the military in violation of rule of law principles and right of fair trial, and that's the the military is above the designation of military officers, the head of the military, and the other branches of the military is not subjected to civilian authorities. It's rather the other way around. And in relation to that, in implementing that vision, I think we are witnessing how the judiciary has been used as a tool of repression. And I think there are two elements there when it comes to the breakdown of the rule of law and the politicization of the judiciary. One is that we are using the judiciary to shield states officials, security members, armed forces members from accountability in cases of human rights violations. And Egypt is conducting state-sanctioned policies on torture and ill treatment, arbitrary detention, enforced disappearances. And in the other hand, we are using the judiciary and the Office of Prosecutors. And when we discuss the judiciary in the context of Egypt, it's military courts, state security courts, ordinary courts, and the Office of Prosecutors. We have also states of emergency prosecution and ordinary prosecutors' office. And those arms are being used to target and to crack down on human rights defenders, political opponents, journalists, and the charges on most of the times are misuse of social media, publishing false information harmful to the state, joining terrorist organization, and Egypt has long history of misusing counterterrorism measures to target individuals who are suspected of opposing the authorities. So I hope I can say that there is light at the end of the tunnel, as you mentioned before, but this is the situation we have in the region. I'll be happy to answer any questions in relation to these two countries. Thank you.
Thank you, Saïd, for this brief introduction to the region and to the problems there. They're quite saddening, but yes, we all have our problems here and need to solve them somehow. I would like to ask Pauline. I would like to ask you a question. Having heard all of this and being a person that is closely looking at the rule of law situation in different regions, through also the lens of a journalist, could you provide your perspective on the issues that were raised? You are covering a lot of countries. Can you bring us closer and your thoughts as a journalist to this?
Thank you very much, Wojciech. Yes, I mean, the first striking thing listening to all panelists is the fact that probably the attacks on journalists happen when there are attacks on the rule of law. It's so striking that Tanzania, as François mentioned, has been in a good situation or improved at some point, especially with the departure of the president. There has been some hopes, and unfortunately the hopes are now forgotten. But the situation in Tunisia, as mentioned by Saïd, was extremely worrying from July 2021 with the new powers taken by the president. The situation, as you described in Egypt, is absolutely terrible. Egypt is a very hard and tough country. So when and of course Poland, and when we listen to all this description, what is really striking is that there is a real parallel between the attacks on the rule of law around the world, the lack of independence of lawyers and judges, and the attacks on journalists. So to give a bigger picture, the independence of the judiciary and the rule of law cannot be fully guaranteed without the promotion of freedom of the press and freedom of expression. And it's essential to protect the independence of journalists and the media, as any infringement on their independence is an equally important threat on the rule of law. I am talking to specialists of Poland, and they know what I'm talking about. We heard many testimonies about the very, very worrying situation. The independence of lawyers and judges is also essential to guarantee the freedom of journalism. And when we look at the situation in Egypt or Turkey or Tunisia, if this independence is not guaranteed, it is not possible for journalists to exercise their rights. So what is independence when we talk about journalism? There are ethical charters of journalism, and they all insist on independence. At Reporters Without Borders, our definition of the index, this tool that ranks 180 countries every year to define how important is the press freedom. It says that the purpose of the World Press Freedom Index is to compare the level of press freedom enjoyed by journalists and media in certain countries. The comparison is based on a definition of press freedom formulated by RSF and its panel of experts. To develop our new methodology that we launched this year, we say that press freedom is defined as the ability of journalists as individual and collective to select, produce, disseminate news in the public interest, independent of political, economic, legal, and social interference. So this notion of independence, this notion of ability to produce some news is extremely important, and that's why it's so related to the rule of law. Professional charters for journalists commit them, and they announce a certain number of criteria that the journalists should respect. They should act honestly. They have to be concerned for the truths of the fact. They have to respect the person, respect the diversity of opinions. They have to refuse manipulation of conscience. They refuse, of course, corruption. They have a duty to publish what is in the public interest. So we are very close to justice again. And in all circumstances, we should be in favor of the culture of doubt instead of publishing information that are not true. So it implies the notion of transparency, the notion of honesty, the notion of quality of information, which actually today is really important because the information is sometimes mixed with fake information, false information. So the notion of quality of information implies that the journalists do not know any obstacles in the access to the sources of information. And it concerns a lot of countries we mentioned earlier, but they have a free access to publish information, which is not easy in all countries in the world. They have a protection of sources. We also face this kind of problems in a number of countries, and including inside the European Union. They have to protect the whistleblowers, etc. There is also a notion of pluralism, because the more diverse voices you have and the more pluralist the media landscape is, the more diverse opinions we will get, and so the information will be more representative. So the more we see situation taking place when the state takes control of the public media and then independent media, and try to silence the media, the independent media, one after the other, is extremely worrying, because the plurality of media landscape disappears. So if we look at the situation case by case, Poland is a very good example. Although we discussed a lot the case, it's really emblematic of what's happening inside the EU. It's ranked 66 by RSF among 180 countries, but it's the expression of an exemplary country that was really a model of integration inside the European Union, and that completely went in the other direction from 2015 with, as you mentioned, the arrival of a new party in power. But what is really interesting is to see that at the very first moment the party took power, one of its aim was to take control of the public media. And that was done within 2 months after they won the election. So it's absolutely clear that there is a parallel between the rule of law and the control of information. Poland is, of course, was following at this moment what had happened in Hungary a few years earlier, and as Wojciech mentioned also, the situation in Hungary was considered as almost lost in the sense that when the Prime Minister Viktor Orbán came back to power in 2010, he actually finished what he had planned to do, and took control of the media after he had taken control of justice. And there was a sense of not being able to reverse the situation. It was something like too late in Hungary. And a lot of NGOs such as RSF learned the lesson, and they were extremely active to denounce the situation in Poland, because they were aware that in Hungary they had not been sufficiently aware and proactive, and that in a certain way lost the battle. So it's never lost, but the Prime Minister was extremely active to try to control the media. We discussed the situation in Egypt, which is extremely worrying, a very good example of lack of independence of journalists and control of media. Egypt is ranked 168 out of 180 countries by Reporters Without Borders, but it's also one of the world's biggest prisons for journalists. As we speak, 24 of them are detained with for arbitrary motives, and the hope that was felt in the spring of 2011 has now seemed extremely distant and has disappeared. The secret services, as Saïd mentioned, use the terror motivation and pretext to detain and arrest journalists. So, of course, the pandemic was a very bad event, really a worrying event, because at this moment there was a very good pretext for some countries, such as Egypt, to arrest journalists on arbitrary reason and to keep them at a moment when it was really difficult to witness the situation on the ground for NGOs and to discuss with people on the ground, because the country was closed. But Turkey is another example of a worrying situation with justice and media, even though with the media it's less terrible than in 2016 after the attempt of a coup. Turkey is another very big prison for journalists. It's ranked 180 and 49, sorry, out of 140 and 80 countries, and we consider that all the judicial suing and pressure on journalists is probably the most terrible, difficult problem for them to do their job in the country. It's RSF regularly calls the justice to be independent in order not to condemn journalists. So it's extremely worrying. Right now, there is also a very a case of a country that expresses the situation a lot. It's Russia. We talk a lot about the invasion in Ukraine, but what's happening right now with the implementation of very restrictive laws against journalists shows that both justice and pressure on the media can be really related. The justice is not independent in the country, and its role, the role it was given by the authorities is to target journalists, to condemn them. Right now, any journalist pronouncing the word invasion or the word war, even though there has been an invasion on from the 24th of February, could be jailed for 15 years, which means that there is a total self-censorship from the biggest media, and from the most famous journalist, Novaya Gazeta, decided to, for example, not to publish anymore its content because it was not possible to produce information. And what has happened in Russia is also was also very visible in Asia, with a total control of the Chinese authority on Hong Kong, with the justice helping the Hong Kong authorities to pressure journalists and to jail them. So not talking about situation in Africa, the Tanzania is also facing problems with the lack of independence of the journalists in the country. It's ranked 124. So all this to say that there is a relation between the two, and it's really clear for me listening to you that we can make a parallel, and both all together we are much stronger to defend the rule of law.
Thank you, Pauline. Thank you for introducing us and to your views, and also to the whole basically scene, how it looks like in the world. I have one thought that when you were talking just founded my brain. I'm remembering the book from Timothy Snyder, professor, on tyranny. And that's one of the points he raises, that independence of journalists who report the truth is one of the key elements and fundaments. The moment when one party to the political dispute questions the motives of journalists and says outright that the other guys are lying, it's the moment when you lose any possibility of a rational discussion about topics. And this is, I think, what we notice in many countries right now. This misinformation and what starts, the other problems. I want to open the discussion a bit to the panel. So having set the scene, let's say, what is the outlook for fixing these problems that you have described? From your point of view, what needs to happen? What is your recommendation? Anybody would like to start with her thoughts? Please, just one thing. I'm a moderator, so need to keep the time. Please limit your intervention to 5 minutes. Anybody?
Well, maybe I will just continue and less than 5 minutes. I think one of the most important thing, working for NGO, it's probably also our role, is to continue to be the stone in the shoe. I think our work in recent years has shown that we can succeed by never giving up and showing that we will never give up. The dialogue with the opponents is essential. Trying to understand what leads to so much pressure, what the authoritarian regime have in mind when they pressure journalists or the civil society, because very often they are in the same, they face the same situation. But dialogue is essential, and just try to understand and reverse the situation and oppose arguments to your opponents, and always make your opponent understand that you will not stop because it's a fight for democracy in general.
Great thoughts. Anybody else? Michał, I see you want to say something.
Yeah, I'm unmuting myself. Yeah. So actually, building on what you've said and what Pauline said, you've mentioned Timothy Snyder, and actually, I was thinking about. There's a great book by Robert Axelrod, which is basically on applying game theory principles to evolution. And what I'm always thinking about is the basic principles that we're dealing with are exactly the same. So the basic thought and the basic mechanism that he's describing is, in any kind of game which could be described in game theory language, in game theory theorems, if one player knows that the other player will catch him cheating, and the cheating player has to play more than one game with the other player, he's discouraged from cheating. And this is basically the same mechanism that we're operating under. For any kind of government, for any kind of public authority to be discouraged from cheating, it has to know that the other player or the other players are watching them. And for this mechanism to operate, we have to have rule of law. We have to have judicial review. We have to have judicial review without fear of reprisal on the part of judges. We have to have independent journalists. We have to have journalists who are not afraid to pursue their subjects and publish. They have to work without fear of reprisals. So this is the first step. And the second step comes naturally, because in every kind of society, all the interactions that we have in a political system are basically a game theory interaction without any kind of ultimate step. So those are the kinds of games that do not finish on a certain given step. And I'm always thinking about Robert Axelrod when we're discussing rule of law and independence of journalists, because this kind of mathematical theory is applicable not only to evolution and evolutionary theory, but all types of social interactions. So when, to conclude, when you're asking what should happen, what should come to pass for us to effectively fight the rule of law backsliding, I think that the independence of the judiciary, independence of journalists is very important. But another important factor is those in power have to be afraid of consequences. I mean, a player is discouraged from cheating only if he's aware that his cheating will have negative consequences for him. So that's the third essential part of the equation that has to be implemented for rule of law to work, and for governments or any other kind of public authorities to basically, work and operate according to the rules that we've all agreed upon.
And this is something that I feel from all the interventions, that in each of the state or the region that we were discussing, one of the topics that comes to on the table is basically the removal of accountability of the governing parties. And I think Saïd was also mentioning this. What are your thoughts, Saïd?
No, definitely. I think when we are talking about the rule of law and the very idea of checks and balances, and that's each branch of government is supposed to be acting as a check on the other branches of governments when they are abusing their powers. The system can only function if those checks and balances are there in place, and if each authority or the authorities are acting within the boundaries provided for by the Constitution and the law. I mentioned the role of the military, and I think this is something that is common in the MENA region. The article I was referring to in the constitutional amendments gives the military the duty to protect the Constitution and democracy and safeguard the basic components of the states and its civilian nature, the military protecting civilian nature of the state, and the people gains and individual rights and freedoms. And that would run against the very basic concepts of the role of the military. So I think when it comes to upholding the rule of law, you need to go to the basic, that military is subordinated to civilian authorities. The judiciary is independent and is able to act as a check on the government, on the parliament, and the principle of judicial review is ensured at all levels, and that laws and decrees are not protected against judicial review. And you would ensure also that the process of developing these laws, constitutions, policies are legitimate and reflects the will of the people through fair elections and elections that reflect the diversity of the populations and the various views within a society. But they are also developed in an inclusive and transparent way, and in a way that can ensure that civil society is able to provide the input and it's able to push or to act as a watchdog and to ensure that such laws and policies are consistent with international standards and the obligations of states under international law. And that can only happen if civil society is independent. And throughout the region, we are having laws, policies, practices that targets civil society organizations as organizations, accusing them of being foreign agents, attacking them because they are receiving funding or supposedly receiving funding from foreign actors, etc. And in not only targeting them at the institutional level, targeting human rights defenders and civil society actors also at the individual level through politicized proceedings, through the misuse of judicial processes, and through travel bans. I'm talking just about the situation in Egypt, the number of human rights defenders and civil society actors who are subject to arbitrary travel bans, who are added to terrorist lists, who don't have even the available remedy to challenge such arbitrary decisions. So I think it goes back to the basics. It can be achieved through and the work at the national level and the coordination of efforts amongst different stakeholders, but also, and it's important to highlight it here as well, the role of the international community and of international actors, institutions in living up to their commitment to the rule of law and human rights, and individual states that have rule of law and human rights as organizing principles of their foreign policy. It's important to live up to those principles and to think that or believe that the people in Tunisia who are fighting for the rule of law, or in Egypt or in Poland, that they are living and they're fighting for the same principles that govern or should govern or in principle are governing the foreign policy of these states. So coordination of efforts at the national and international level, and the fight for the rule of law never ends. So we have just to continue.
Yes, I think these events and this discussion actually, and this webathon is one of the important pieces of the puzzle, let's say, in the fight for the rule of law, and also in having and living by these standards. François, sorry to cold call on you. You were talking about these different trends in Tanzania. Can you do what do you think? Can they be reversed? And what role does governance structure play in all this, and leadership? Can you elaborate a bit more?
With pleasure. And such a question allows us actually to expand a bit the analysis and discuss a bit more precisely about journalists and the environment in which they have to operate. For instance, if we were to identify the 12 worst countries on press freedom in Africa, what would they have in common? I can give you a hint. The list have just been published recently in the last week or so. And we can see that starting at the bottom of the list is Eritrea, closely followed by Egypt, which we have discussed today. But there's after that Djibouti, Sudan, Libya, Equatorial Guinea, Somalia, Zimbabwe, Rwanda, Western Sahara, Algeria, and Uganda. So by looking at that list, we can look at trends, we can look at similarities. And all of these countries are having either autocratic governments that maintain themselves in power through a variety of means, including coercion, or have unstable or failed states to govern. So we can easily identify the impact of government structures and democratic processes, or the lack thereof, which they can have. And obviously this highlights the paramount importance of leadership. Such rankings are produced by utilizing a series of indicators. I know that those that are making for Reporters Sans Frontières this particular ranking have used the political context, the legal framework, the economic context, the social-cultural context, and security. And we can clearly see by that list that the political context one, so we go back to the governance and leadership, becomes the overarching criteria that more or less explains all others. Therefore, one can easily say and conclude that, yes, the Constitution guarantees rights and freedoms, but in practice, these are hindered by a series of laws, which can take a variety of forms depending on the country's specific context. I've mentioned a few when I was discussing Tanzania, but they can be different in any other jurisdiction. More importantly, though, it's the leadership style of the person in charge that influences how these laws are enforced and how critical voices are treated. Especially for the most autocratic countries, it is going without saying what the end result should be. There's no need for a direct involvement of the people in power. It is known across the architecture of what needs to be done in specific circumstances. And I believe that this is where Tanzania can provide an interesting and concluding tale here, starting from beginning and then finalizing with them. Since the new president came into power, while the last one died in office, these limitations continue being imposed, and none of the legislative amendments have been abandoned, but we can clearly see that they were relaxed and they are reduced in scope. So while the apparatus still exists, there's kind of an understanding through that new, more calm style of leadership that this is no longer the main way of operating. As such, we can report that since she came to power, we don't necessarily have newspapers that have been banned, that journalists have not been arrested, that no NGOs were banned, and even that opposition leaders have been freed or returned from exiles, especially if we're mentioning the name of Tundu Lissu, who has suffered a failed execution attempt. But we have to remain cognizant that the legislative basis for that coercion remains in place and could be reimposed with renewed vigor at any time. And opportunities for such change of tune seems to exist. So we have to remain on our guard and careful. It seems, however, that these opportunities and a promise for better practices from the executives exists, and we can continue striving under them, under the current leadership, if nothing changes, of course. To highlight a bit, therefore, the importance of distinguishing between overt criticism of governments and something that we approach mostly as a constructive dialogue or advocacy, I can give you the example of this event that is being organized a bit later this week. I've mentioned the Center for Civil Strategic Litigation earlier, but now another very vibrant and strong organization in Tanzania called the Tanzania Human Rights Defenders Coalition will be celebrating their 10th anniversary. And this event will be hosted by under the high patronage of the President of the Republic of Tanzania. And we can see from the list of confirmed participants that there's multiple current and former justices and ministers that will be present. And this event serves as a celebration of one of the most vocal, influential, and combative civil society actors that there is in the country, and the one that are actually at the forefront of fighting for the maintenance of this right to do public interest litigation in the country. So there might be hope after all. We have to remain cautious, remain on our guards, but there might be hope that a change of leadership and renewed perspectives on how to analyze the role of civil society can actually change. Thank you.
Oh, thank you. This is really great and some very interesting points here. Pauline, you wanted to say something. I see that you're unmuted.
Wojciech, I wanted to pick up from François' intervention and just to recall the situation right now after 2 years of, the sort of end of the pandemic. But it's very important, I think, to also recall that although fake news is some argument that is used by a lot of states to repress journalists, the COVID-19 pandemic has been also the pretext for a number of countries to pass some new regulation targeting disinformation, according to them, during the pandemic. And this had also led authorized autocrats to new censorship tools. So I think it's very important to recall that this all happens after we have been through a very difficult situation with our rights, our freedom of movement, and for journalists, their freedom to say, report, and in Tanzania, for example, there are still some rules against all words cannot be pronounced or used in the media regarding in the medical sphere. So I think it is very important to recall all this as we speak.
Yes, this is correct. We also, there's this element of COVID, right, and post-COVID world, and a lot of this legislation that, for instance, we witnessed in Poland, it was passed under the radar when people were really thinking about COVID. So a lot of restrictions, and also a lot of restrictions on journalists placed in Poland regarding COVID and the other migration crisis that we had on the border of Poland and Belarus. So these two things. So after discussing these topics, I have also would like to pose one question to the panel, and I think it's like a bit of a summarizing question, and I think a hard one. And please feel free to jump in whenever you're ready to answer. Are we actually witnessing the fall of democracy with all that you said? And who will win in this clash of democracy versus authoritarian rules? Will these authoritarian rules prevail in the future? If we're talking about, dealing with crisis situations like COVID, maybe this is the reason that there's a push towards authoritarian rules. So the last question within these, is the rule of law in this Western sense that we think of, whether it's possible to replicate somehow in the under authoritarian rules, I mean, in some modified form? What are your thoughts on this? I'm really struggling with this question.
Maybe I can start and try to respond to whether it's the fall of democracy. We'll have to see. I think democracy is on retreats, rule of law is on retreats, human rights on retreats, and we are seeing that authoritarianism is rampant, is gaining grounds in well-established democracies, and in democracies that are young, as is the experience in Tunisia. In less than 10 years, we are basically returning to to the very beginning and to a situation in which the president controls all branches of government. So democracy is in retreat. I think we should just be careful in terms of branding it as the Western sense of the rule of law. I think when it comes to the basic foundations, the basic values of the rule of law are universal values. When it comes to the right to an independent tribunal, that's not a Western right, that's a universal right that all countries, or at least the countries that are part of the UN system, recognized and committed themselves to uphold. And that right to an independent tribunal involves all the questions related to appointments, transfer, disciplining of judges, and involves, as interpreted by the Human Rights Committee, involves that the executive branch should not have an influence or control over the judicial branch. If we are talking about the very principle of separation of power, that's also derived from the right to an independent judiciary, from the rights of individuals, and I think people don't necessarily, or at least, that there is a denial of the rights of individuals to take part in the conduct of public affairs, as recognized by the International Covenant on Civil and Political Rights. And that's also a right that, as was interpreted by the Human Rights Committee, involves the right of people to choose freely their form of government, to elect people, to participate in elections. So all these that we are considering as foundations or basis, these elements that are the foundations or the basis of the rule of law, are also human rights that most of the countries, if not all of them, accepted and signed conventions to uphold them and to protect them. And it's important in our fight for the rule of law and for human rights to challenge this idea of a Western concept and to hold state to account and make sure that they comply with their obligations under international law. The countries, and I think it's important to highlight here, when we talk about Poland, about Turkey, about Egypt, about what's happening in Tunisia right now, the modus operandi of this authoritarian regime is the same. You target the checks on your abuse of power. You target civil society. You target the judiciary, you target journalists, you target free and independent media. And why you target them? Because those are the institutions, those are the bodies that are able to hold you to account and to act as a check on your abuse of power. And for us, and I think this is also just to reiterate the points, if the fight for the rule of law is to succeed, I think all countries that consider the rule of law and human rights to be organizing principles of their policies and of their foreign policies to act accordingly. Authoritarians are not shy in terms of supporting one another, and they are not shy in terms of providing aid and comfort to each other. I hope that democratic governments are not shy in terms of support for the rule of law and human rights, are not providing comfort to dictators and providing red carpet to them, and are not shy also in terms of providing support to those who are on the front lines, lawyers, human rights defenders, journalists, and who are fighting for these universal principles. And again, I'm highlighting they are universal rights and universal principles, not Western ones.
Yeah, thank you, Saïd. I managed to provoke you a little bit with this Western rule of law, but I really wanted to hear this. I guess I would summarize your intervention as the rule of law is in retreat, but there is hope. Anyone here thinks differently? Do you also see a light in the tunnel? Anybody?
Yes, please. If I can just build on this, it's a bit outside of the talking points I had prepared for today, but once we are defining the rule of law as Western type, this attracts my attention. And I think that I will not call that an opportunity, but it will provide a window into what rule of law actually means for Western countries. The current situation, many countries, developing countries, are facing the trifecta or a perfect storm. They are facing higher costs for most of the commodities that they are purchasing internationally, oil, grains. They are still juggling with coping with the effects of the pandemic. and they are seeing the increase in inflation and interest rate, which is having an effect on the cost of their debts. So now faced with these three consequences, there's a chance that there's some defaults associated with that. And outside external factors that are not related to the countries themselves are actually having a disproportionate impact, and a solution will have to be found. And we saw the first domino to fall, was it, I believe today, that Sri Lanka, the prime minister has had to flee due to growing pressure from civil society and the citizens in general because of the effects of these three causes that I've mentioned. The IMF comes to the rescue, as they normally do. They will provide a series of measures, a package to resolve. Some of them will have a lasting impact on civil society, on the society, on the economy of these countries. But they are not the only ones. And already the IMF is in discussions with two of the countries that was discussed today, Tunisia and Egypt. They are two of the main importers of grains from Ukraine and Russia. So through that negotiation, it will be interesting to see what is that concept of Western rule of law, on how they will actually impose restrictions to receiving that aid associated with freeing political opponents, reducing the damages that they are causing to the free press, to releasing some of the journalists that have been incarcerated. The number of 24 was mentioned. How will they actually implement this series of measures to actually demonstrate that they actually move with the talk and that these concepts that are retreating are actually important? So this is something that I think will provide a window, or actually a framework for analysis of really what do Western country means when they put emphasis on democratic principles or to the rule of law itself. Thank you.
Yeah, thank you a lot, François. Then a really quick question: democracy and rule of law in retreat, or in attack? Maybe. What's your thought?
Well, definitely in retreat, but I would say we should put more emphasis on the rise of nationalisms, which also have an effect on these two other concepts. So this is what should be more worrying. And we see some examples of that already having a trickling effect in third countries. Africa has been, unfortunately, affected by this in the past. So hopefully that's not something that will repeat itself, something to keep monitoring.
Thank you. What about Pauline? What are your thoughts?
Well, my thoughts listening to François is to say that I think there is a sort of what's happening in Russia right now is also a awakening call. I think some states that were thought to be extremely authoritarian have also proved and expressed their support to Ukraine or condemn the war or the invasion. So there is hope. There is always hope to reverse the trend, even though right now we are going through this very terrible moment. The fact that some states have, not all unfortunately, but some have expressed their condemnation of the war and their support of the democracy is absolutely essential. So that's, of course, there is always hope, and we have not lost the battle for sure.
Okay, that's reinforcing. Michał, what about you? What is your thought?
I'm actually kind of conflicted because I think what is often done is conflating a lot of, at least a couple of trends which can be seen, and talking about whether democracy is retreat is kind of conflating those issues. I think maybe what everybody should be looking at is trying to discern separate trends within this broader concept, because I think we can still talk about a democratic political system, but with varying degrees of journalist freedom. And we can still have a democracy where journalists' freedom is limited. And this is what's happening, for example, in Poland, because we've been seeing limits on the freedom of journalists and freedom of access to information. And as of now, we're not yet talking about Poland not being a democratic state. So there's definitely a trend of limits on freedom of information and access to information. There's definitely a trend of societies not having access to worthwhile information. Societies having access to less and less information, which actually gives adequate information on what's going on. This is definitely a trend. Whether we can disassociate this trend from the issue of political freedoms, and whether we can disassociate entirely the issues of access to information from issues of political institutions, probably remains to be seen. In extremis, probably not, but as long as we're not in the in a cornerstone, in a corner situation, in a corner case, we can probably talk about those trends as being separate. And another important trend is what we're seeing in Europe. I don't want to be Western-centric about this, but I can talk with some authority on what we see in Europe. I don't want to talk about Africa or Asia because I don't know enough to talk about those polities. But in Europe, we can see divergent trends concerning the interpretation and scope of basic human and political freedoms. What we see in Poland and in other Eastern European countries is a trend of diverging in interpretation of what political freedoms and what basic human rights pertain to all of us as humans. And whether this, again, whether we can sustain this trend without ultimately destroying the political unity of the European Union remains to be seen. If that can be done at all, that would require a very deep reimagining of the structure of the European Convention of Human Rights, of the Charter of Fundamental Freedoms. So I definitely see those trends. They can definitely flow in the same direction, but not necessarily. And I think this is because we have a couple of trends, judging with any authority where is this all taking us is very, very difficult. Talking about Poland, because probably this is the polity that I can talk about with the most authority. I'm fairly confident that Poland will remain a democratic state. I mean, I don't foresee us not having elections, but definitely those elections will be impacted and are being impacted to a certain degree by the government controlling the state-owned media outlets. So what I'm basically saying that it's a continuum. It's not on or off. We're on a continuum, we're on a scale, and the sliding counters on those scales can move a little bit independently of each other.
Anybody would like to comment on what Michał said? If not, Pauline, yeah.
Yes,
go ahead, please.
Again, but Poland was very somber, very dark until it showed its ability to be an open country and just take emergency measures for Ukrainian in exile lately. And even though one is aware that Poland is probably also whitewashing its image and reputation because of course its image has been very damaged in previous years, it's the evidence that democracy wins, and at the moment when human rights are at stake for real democracies, they are able to act and take really important steps, such as what has done Poland. So for me, it's a really big sign of hope to see this change and very sudden change.
I mean, what Pauline said, if I may, Wojciech.
Yes, go ahead. We still have some time.
So what Pauline said actually is important as an excellent example of what I've been talking about, because we've had the refugee crisis. I mean, a human rights crisis actually, with refugees being stranded on the Polish-Belarusian border, without access to aid, without access to medical care, and the policy of forced pushbacks of those refugees to the Belarusian side of the border, with blatant infringements of human rights happening every single day. But on the other hand, you know, after 24th of February, Poland has opened its borders to millions of people from Ukraine, and those people have come into Poland, and they've been welcome. So how does one balance one against the other? How does one come to any conclusion about what is the ultimate approach of the Polish state or of the Polish authorities towards the policy of open borders and towards refugees? It's very hard to reconcile. And like Pauline said, using the situation in Ukraine can be used as whitewashing the state's policy towards refugees on the Belarusian border. At the same time, you know, it's unequivocally the Polish state is helping those millions and millions of refugees from Ukraine. So it's, from a moral perspective, it's very difficult to balance and to come to any overarching conclusion. From a legal perspective, of course, helping Ukrainian refugees does not wash away the stain of what's happening on the Belarusian border, and does not affect the absolute illegality of what's happening on the Belarusian border.
Maybe, you know, just to follow up on that, I think the rule of law provides that perspective of that the equal protection of the law means that the same rules apply to all. So if we are dealing with the issue of non-refoulement or protection of refugees, that shouldn't be based on religion or the color of skin. And I think it's important to highlight that this is not a matter of moral issues or moral appreciation of it. We are talking about binding legal principles that should be guiding the conduct of states in dealing with these issues. And when it comes to absolute prohibition of non-refoulement, when it comes to absolute character of non-discrimination, those should be the elements through which we should judge the conduct of states. And it's important, while we are highlighting that there are nuances to be there, to also think of the rule of law as a dynamic, but also substantive concept. That's the rule of law is not only having elections that are not manipulated by the Ministry of Interior. Rule of law is ensuring that oppositions and other stakeholders are able to have access to free media, are able to make the case for themselves and for their ideas without fear, without intimidation, without harassment, and that the people are informed to make decisions accordingly. So when you restrict the civic space, when you take control over the judiciary, when you are disbanding or dismantling all the checks on your rule, and you are just reducing democracy to this kind of formal act of people going to to vote without being restricted. I think we have just to be concerned about reducing the very concept of the rule of law and democracy to elections that are organized regularly and without direct intervention. It's also important to focus on the context and the conditions under which such elections are conducted. And it's important to highlight the importance of principle of inclusiveness and transparency to the establishment of the rule of law.
Absolutely.
Yes.
And if I may just say one word about what
Two
Saïd
sentences,
said.
Michał, please.
Yeah, so absolutely I agree that there is a hard core of what rule of law means, and there is a hard core of what independence of the judiciary and democracy means. And absolutely, without free elections, without all of the other parts of the mechanisms are meaningless. So I totally agree.
So the role of the moderator is very hard because the discussion when it's going, I would love to continue, but unfortunately I need to end because we are going on to another panel. So first of all, I would like to thank the speakers. Thank you a lot for this interesting discussion. Many thanks. Thank you to the organizers. Thanks, Jacqueline, for being with us and for organizing all this. And thank you all that are listening to us for joining us, our panel, our unprecedented 24-hour webathon, which you can see actually at the back. I started with the sun, and unfortunately it's already night, so it's really going 24 hours. It's all lawyers across the globe and around the clock for the rule of law. It doesn't stop here. At the top of the hour, we'll go live to Latin America now. To join the American Bar Association, International Law Section, and Asociación Nacional de Abogados de Empresa from Mexico for a panel discussing defending poverty in the Americas. Is formal democracy enough? Also very interesting discussion. Please join that panel. And once more, thank you everybody for joining us, and thanks a lot for this speakers. Thank you.
Thank you. Thank you very much.
Thank you. Thank you.